All right. Let's get back organized here. Right, we've got one last case, Coombs versus Liberty Mutual Fire Insurance Company.
Good morning. May it please the court, Matthew Struble for the appellant. I do intend to reserve 5 minutes for rebuttal.
Got it.
And in this case, the trial court erred by not finding as a matter of law that the insurance company's denial of the claim waived later complaining about compliance with post-loss conditions. That's the exact type of error that has been specifically corrected by each of the other 4 district courts. It starts with most recently out of the 4th District Court of Appeals just 2 months ago in the Bryant versus Giovera case. In that case, the court reiterated that longstanding principle of law that denial of a claim waives compliance with post-loss conditions. In that case, the insurance company had requested a proof of loss on May 16, 2014, and then later, about a month later, denied the claim, saying it's excluded under this 14-day provision.
Let me ask just, do you all, and I'm going to ask this of both sides, but neither side cited to Curran. Do you think that Curran's inapplicable to this case?
Curran is certainly related, and I think
you didn't cite it in your brief, so apparently you didn't think it was important enough to put in a brief.
Right. It was related. It was related down below. Yes, I didn't think it was. We didn't put it in the brief for the reason being is that we don't think we need to get there. As a simple matter of law, they waived any compliance. But related to that, the 3rd DCA did just recently certify a conflict out of this 5th district between the Whistler's Park decision and the Farmer decision, both out of this court, because this court has differed on who has the presumption of prejudice and who has to prove it. So there is.
How was it ever determined that the notice was untimely? I mean, it seems to me that you don't even get to the question of waiver and all this other stuff if there's not a determination that the notice was untimely. And when I look at the verdict form, the first question is, did Combs prove by the greater weight of evidence that they waived their requirement to comply?
Right.
Well, I mean, the whole issue comes down to, was she late reporting or not? Because if she wasn't late reporting, then we don't have a fight. How was it ever determined in the first instance that she was late reporting?
The trial court was presented with basically what the burden shifting is and ended up giving instructions in that way. And we certainly agree that that was wrong. There's factual issues as to whether it's notice or not, but our point...
But you haven't appealed that...
Not that specific issue, we have not. And because our position as to that is you never get to that. If there is a waiver, you never get to all those factual issues. And as you see, we tried this case because we had to. So when the court denied our motions on the waiver issues, we had to go try the case. We put on facts. It was difficult in this context to ultimately get here. But our position throughout was you never get there because if you waive it and they're not allowed to assert it, then you never go down that whole road. So that was the main issue that we have, and that's an issue that is 100% a matter of law for the court to determine. The court ended up deciding not to go our way on that case, but as I indicated, the 4th has made it abundantly clear on the exact same scenario. When they did the same exact thing in that case. They denied it, saying the 14-day exclusion applies. Later tried to assert policy exclusions. The court said as a matter of law, you cannot. You have a case out of the 2nd DCA as well, Castro versus homeowners. In that case, the insurance company investigated it. They denied it. They later on started asking for an examination under oath after they had denied it. The insured did not comply. They filed suit, and the court held as a matter of law, you started asking for compliance with conditions after you had denied the claim. You waived all your right to do so.
But counsel, don't those cases really hold that the insurer was not entitled to raise those issues as a bar to filing suit, as opposed to a defense to the claim?
No, they're all the exact, so even the Bryant versus Giovera case, they had asked for a proof of loss, then denied the claim, then suit was filed, then they tried to raise that defense of not submitting a proof of loss, and the court held, you can't do that. And that's our exact scenario. So in our case, they denied the claim within 10 days of receiving it, within 2 days of doing their inspection, saying, hey, we think this 14-day exclusion applies. That was the sole basis for their denial. Years later, the homeowner ends up finding basically people that can help her, suit gets filed, and then for the first time, when they file their answer, they raise this issue with compliance. And this case is, I think the prime example of why this basic rule of law exists. So for example, the first time they asked for receipts in writing or anything is during litigation, and her response is, this 2 years ago, I replaced my AC unit, you never asked for them, would have given it to you at that time. All the repair work is on the old AC unit that I don't have because you just denied my claim within 2 days of the inspection and within 10 days of receiving notice. And I think that's why this basic rule of law exists, and particularly when you look at the over-encompassing law in Florida of disfavoring forfeiture under insurance policy provisions. In every single case cited by either of us that's actually in the insurance context makes clear that when you deny the claim, you waive the right to later assert policy conditions. And in those cases, there's much more extreme examples where they denied it, and then before a suit's filed, they sought compliance, right? They actually asked for proof of loss, or they actually said, we have an issue with compliance. And then that was still found to be a denial. So our case is the strongest example of that. And so we think that as a matter of law, the court erred by not finding that their denial of the claim was a waiver. So that's, I think, the only issue that needs to be reached in this case. We have much more arguments in addition to that, for example, related to the prejudice issue. Again, we don't think we need to get there because you don't get there if there's a waiver. But as to the prejudice issue, we show other examples of cases, such as Hartford versus Phelps, where the insurance company gets notice of the claim, they investigate it, and they say, according to their investigation, they were able to determine the claim is not covered. That's what happened in this case. They get notice of the claim, they go out, they do an inspection. 2 days later, they say, oh, we were able to determine what the cause of loss is. We think the cause of loss is not covered. They never once asserted, hey, we're prejudiced, we have any issues. It showed the exact opposite. According to them, according to their own investigation, they were able to determine the cause of the loss. The issue they had is that part of the reason we brought this case was brought as a declaratory judgment, and basically we were seeking, as part of it, the decision that was rendered by this case in the Hicks versus an American Integrity case. That came out after our suit was filed, so then it became pretty clear, and they don't really dispute in their answer brief that they got their denial wrong. They completely misinterpreted their own policy, and they don't really try to put up a fight about that in their answer brief. So once the Hicks decision came out, that kind of went out the window, and that's what we had, the other thing we had been seeking at that time. So the only thing they really had left, and the only thing they're still trying to argue, is the policy conditions, which they waived as a matter of law. So the court erred by not finding that. It also erred because, as we said, there was, in reviewing the evidence by their own admission, they were able to determine, they had initially said, the cause, and that was excluded. And they never took the position that their investigation was prejudiced by getting late notice on the claim. So either of those two things require reversal. We think we only have to get to the waiver argument. And then as to the exclusion.
The counsel, doesn't appellee contend they were prejudiced because they weren't able to, if I understand their argument is, had it been reported sooner, they would have been able to do an investigation immediately, or
yep, so
as soon as they got notice.
They made that argument at trial. So at trial, evidence was coming out. They actually don't know. They can't actually say the damage was more than 14 days. They have no evidence of it, even though they had denied it on that exact basis. So once all that evidence came out on trial, they said, yeah, we got it wrong, but maybe if it was reported sooner during trial, they started making arguments. But what you have to look at is their actual investigation of their claim. Their investigation of the claim was they received notice, they do an inspection. 2 days later, they say, based on our inspection, we figured out everything that was going on.
Didn't the jury make a determination as to prejudice?
Yeah, so that was submitted to the jury. Again, we didn't believe that it should have been submitted to the jury, especially in this context. That was another thing that, as a matter of law, we believe should have been ruled on. So yeah, since our motion was denied, we put on facts, we had to get it to the jury, obviously, to get a final judgment that could be appealed. So it did ultimately go to the jury, and our position was it never should have been, and we made that very clear in our motion for directed verdict that we moved for. And then as to the last part is, as to the exclusion, this court has already held that the exclusion in Liberty Mutual's policy and the way they denied it is ambiguous and needs to be construed in favor of coverage. That's this decision that came out last year in the Hicks versus American Integrity case. So we argued that with the trial court. The trial court didn't go our way on that. We argued it in our brief. They don't dispute that in their answer brief. They just say, no, we think you don't need to get there because of the conditions. And in this case, it's very easy for this court to deal with it because at the lower level, the issue of damages was never presented to the jury. The sole issue presented to the court was coverage. So this court could very easily reverse it, send it back saying that they waived their policy conditions as a matter of law and just order further proceedings. What that would consist of is basically one-day trial to establish the amount of damages.
And what's your best case for your argument that they waived this as a matter of law?
I would say I have a best case from each district. From the 4th, it would be Bryant versus Giovera. From the 3rd, it would be 2, Wegner versus International Bankers in a citizens case, IFEGANE, citizens. That case is important to look at because what it says is that the only time there's ever can possibly be a factual issue is whether there's a factual issue about whether they denied the claim or not. So when you look at the citizens case out of the 3rd, in that case there was some typo in the letter. It kind of said it denied and it kind of said they didn't deny it, so there was a factual dispute that the insurance company did indeed deny the claim. All the cases that they cite to where they try to say it can somehow be a factual thing are insurance context cases. They're completely different cases. The insurance context cases make it clear if they deny it, which is undisputed in this case that they did, then it's a waiver as a matter of law.
Counsel, the cases that are cited regarding the presumption of prejudice, if it's established, and you've conceded that issue was sort of glossed over at the trial court, it's not on appeal, but if it's established that the insured did not give timely notice as required by the policy, then that's the burden on the insurer normally. That's not on appeal, but if the cases that deal with that say that the burden's on the insurer, if they show that there was a violation of that provision of the policy regarding timely notice, then the burden shifts to the insured to show there was no prejudice. You're familiar with the cases that I'm talking about?
I am, but there's a conflict in the 5th right now. This court has said in Whistler's Park that the burden is on the insurance company, and in Farmer versus Allstate it said the burden is on the insured.
But the burden of proof issue wasn't preserved below, and it's not before us today, is it?
No, as I said, as to the burden, no. We certainly said as a matter of law, they can't say they're prejudiced when according to their own claim position, but yes, 100% correct. So that is an issue that is outstanding, but I don't believe that particular issue is properly framed.
So in that case law, when they're discussing the prejudice issue, that the insured would have to prove lack of prejudice to the insurer, are you saying in all those cases the insurer did not deny coverage?
Yeah, in all those cases, they didn't deny coverage because they're saying it's excluded. And some of them, they denied it saying you didn't comply with policy conditions. And then, of course, then they're able to litigate that issue. Never has there been a case where they denied it based on policy exclusions, and then later on they raised for the first time in litigation policy conditions and then litigate that. So that's the difference in why you never get to any of those issues here. They denied it solely saying that the claim was excluded under the policy.
But in the cases where they have found that a denial of coverage precludes you, I believe the cases say really preclude you from bringing suit. But to the extent you're arguing that what they hold is that preclude you from raising that breach as a defense.
Yep. So
your argument would be if in order to preserve that issue, they just can't deny the claim. They just have to not respond and sit back and wait, even though they believe and they've concluded based on their investigation there's been an untimely failure to report.
It has to actually be an issue, yeah, in the claim. So, for example, we look at Castro versus homeowners, they denied the claim. And then after it was denied, they received more documents. They asked for an EUO. And then suit was filed without an EUO ever being given. And the court, the second district said, well, they had denied the claim before they made the EUO request, so they waived that. In our case, it's much, much easier than that because they denied the claim, never made any requests at all, and then suits filed. And after suits filed for the first time, they raised this conditions issue.
But isn't that distinguishable from a notice of loss, a notice of the claim, in that the purpose of that is to allow the insurer to do an investigation. And the insurer can never go back in time. So if the insured waits 2 years,
So
you're saying if the insurer denies the claim based on you're saying this loss occurred 2 years ago, that's untimely, that's a breach of our agreement, we're going to deny your claim because you breached our agreement. Now they're precluded and they've waived that?
Yep. So, for example, the Wegner versus International Bankers case, that was a notice issue that was waived as a matter of law because they denied it based on coverage issues. Certainly would apply here, and it makes sense because if they are going to say, hey, we didn't get timely notice, well, then they certainly should assert it. For example, in this case, if they said, hey, we didn't get timely notice, we couldn't figure out our investigation, we couldn't figure out what was going on, then the insured would have had an opportunity to say, oh, okay, well, what do you need? I could get you, here's my plumber, I can get you this information, here's the person I had in my home, what else do you need? Because whatever, if you think you have any issues because it wasn't timely reported, let me know so that then I can go ahead and get the information you need to make your investigation.
But
I
isn't
believe
it
that's
true-
the policy behind the law.
But isn't it true, though, what the insured can never do is go back in time and take the insured back in time? They can't fix it. It's not something that can be fixed by the insured, is it? That is, can they go back in time and report the claim?
Can't change the dates, but certainly more information could be provided to aid them in their investigation. So as I kind of indicated, if they thought it was a month late, well, she could have said, okay, well, let me go get my plumber and he'll give you all the information you need. Could have done all of those things. And that's I think the purpose behind the very well-founded law that not doing that results in a waiver.
All right, you're into your rebuttal time.
Okay, thank you.
All right.
Good morning, and may it please the Court. My name is Ryan Jones, and I represent Liberty Mutual. The appellant in this case is asking this Court to create a rule that any insurance policy provision that is not cited in a denial letter is automatically waived. That is not the state of the law in Florida, and it cannot be the state of the law in Florida. Our briefs outline a number of cases that reject that specific principle. The first example that I have for you is Aetna versus Deluxe Systems. In that case, the insurance company denied a claim specifically citing 2 exclusions in the denial. However, when it went to court, the insured argued that every other policy provision was waived, and the trial court agreed. But on appeal, that was rejected, and the appellate court specifically said, we must consider the entire policy. And the reason I stress the word entire is because it didn't say the 2 exclusions in the denial. It didn't say all of the exclusions in the policy. It said the entire policy, which deals with the exclusions and the conditions. Another example of that's very, very similar to the facts here is the Phelps case that appellant raised. In the Phelps case, it was a property damage claim that was denied originally for a groundwater exclusion. However, when it went into litigation, the insurance company raised a late notice defense. And what's really important about that is there was no waiver of that late notice defense. Both the trial court and the appellate court actually addressed the merits of the late notice. They went through the late notice prejudice analysis and ultimately concluded it came out differently, that the presumption of prejudice was overcome, but it addressed the merits of that case, which is very, very important.
How was it determined that there was late notice in this case?
Your Honor, that's the same question you asked appellant. It was actually at the charge conference, which I do not believe was in the record. There are a number of different questions that are typically presented to a jury in a homeowner's case, the first of which is, did the homeowner prove that there was damage during the policy period? And appellant's counsel and I were both trial counsel. We stipulated that was unnecessary because it wasn't disputed. The next issue would have been, was there a failure to timely report the claim? We also agreed, when we agreed on the verdict form, that was unnecessary because it was beyond dispute. It was at least a month late and possibly, depending on the testimony, up to 4 months late. So that issue wasn't tried to the jury and it wasn't raised on appeal. which means we don't have to consider that on what we're looking at today.
You would agree with me, though, that the law generally requires that there be proof that there was a late notice, and that can vary. I mean, I guess, you know, some people will call their insurance company 20 minutes later, and some might wait a month, and some might wait 3 years. I guess a lot of it just depends. But let's come back to the issue of prejudice. I mean, the evidence suggests to me that y'all didn't have any trouble adjusting the loss. You sent your guy out, he did what he did, and you wrote a very clear letter that says it's not a covered loss.
Well,
And there was, I'm just trying to understand why that, how you can possibly be prejudiced. I mean, I can understand if he said, look, I need some more information, or who fixed your air conditioner, or when did you replace it, or how do you service it, and she refused to give it or something. But I didn't see anything in the record that would suggest that they had any difficulty at all in determining, you know, we see what you got, it's not covered, goodbye.
there actually were a number of requests for that information, Your Honor. When the claim came in, the record shows the very first communication back from Liberty Mutual asked the insured to make any repairs that are necessary, to save the receipts, to take photographs of the damage before the repairs, and to provide that to Liberty Mutual. Additionally, the record shows from the adjuster's testimony that when he went to inspect, he asked the insured about who the repair company was and what repairs were done, and that information was never provided. So that information was requested, but it wasn't provided. What Liberty Mutual was ultimately left with, when it showed up on the scene, there were signs of rot, deterioration, and what the adjuster described as long-term damage in the garage. And that's all Liberty Mutual had to make its decision. So what it did is it looked, it saw that information, it saw exclusions for rot, deterioration, and long-term water damage. And that's what it cited in the denial letter.
Do you agree that, I mean, it would have been just as easy to say it's long-term damage and it's not covered, and oh, by the way, we asked you for this information, you didn't give it, and you were late reporting. I mean, that wouldn't present some insurmountable burden on the insurance company.
It certainly could have been done, Your Honor, and it wasn't. The key that we have to address today in this appeal is whether the omission of that statement from the denial letter is sufficient to waive the policy conditions. And I'd submit that there is no case in the state of Florida that says that is the case. The examples I just gave in Aetna and Phelps show the complete opposite situation. Now, what I do want to talk about is the converse of those cases in situations where the conditions were waived. The cases brought up by appellants counsel, Bryant and Wegner and Castro, all of those deal with a situation where the court engages in not just a simple, bold rule that they weren't cited and therefore they're waived. The court actually looked behind the reason, and this is key. The reason those policy provisions weren't relied on at trial is because they would have been futile acts. Each of those cases dealt with a situation where the claim was already denied. So, for example, in Bryant, the amount was paid while the proof of loss was still outstanding. So the proof of loss being submitted wouldn't have changed the facts at all. Likewise, in Wegner, it mentioned the futile compliance with conditions. That's the key to all of these cases. Would the compliance with conditions have been futile or not? If it would have been, certainly you can't rely on the provision later on. But here what we're dealing with is timely notice, providing documents upon request, and showing the damage, the photos, before the repairs were taken. We can't say that's futile because we don't know what would have happened. And that, Your Honors, I'd submit is why the Second District, for example, said typically these waiver arguments are a question of fact to go to the jury. That's exactly what happened in our situation. This was presented to the jury, and they found prejudice here. They found it wasn't overcome. And to get to Judge Cohen's question when it speaks to prejudice about the Curran case, I don't believe it's applicable. Nobody cited it in the briefs, and the reason that I think we can do away with addressing that is because it dealt with a CME provision, which the Florida Supreme Court later in the Curran opinion stated was distinct from policy provisions in a homeowner's case, the duties after loss. So I don't think we have to worry about that.
It's a condition preceding versus condition subsequent issue?
That's exactly right, Your Honor. It's a different burden of proof with those two, and it's a different part of the policy that those two are dealing with. The more applicable cases, and I don't think anybody is disputing, that when there's a failure to comply, a presumption of prejudice arises, and the insured has the burden to overcome that. And that's what we were dealing with here. The Florida Supreme Court's outlined that very clearly in the Bankers versus Macias case. But what is very, very important is the waiver issue. There are no actions, other than simply omitting the words from the denial letter, that would have suggested a waiver. In fact, the denial letter itself even suggested, we do not waive anything under the policy or the law. That makes it clear that there is no voluntarily relinquished known right. That's what needed to be found.
That sort of reservation of rights you just referred to, was that expressly written in the letter?
It was, Your Honor, and there was testimony both from the corporate representative that was written in the letter itself is in the record and in evidence, and the corporate representative then reiterated that position on behalf of Liberty Mutual that it never intended to waive anything. So we do have that in the record, and we do have that expressly made, which brings us back essentially full circle to the only way to find a waiver here is if there is a hard and fast line that says anything that is not in a denial letter is absolutely waived. And as I've talked about and the cases I've cited show, that's not the state of the law in Florida today. And furthermore, it cannot be the state of the law in Florida, and this case is a perfect example of why we can't make that type of a rule. The reason this case fits that so squarely is here initially, and the record will show that initially, Ms. Coombs reported water damage in her garage. And when Liberty Mutual went out to inspect, they saw the damage on the drywall by the AC unit and the baseboards. That's what was initially adjusted. But when it came time for litigation, Ms. Coombs described the entire area as flooded. And then there was water in the laundry room and water in the bedroom. And by the time we got to trial, at the cross-examination of the public adjuster, the record shows we were talking about damage upstairs, in the hallway, down the hallway to the living room and the dining room. So we had much more than was initially inspected by Liberty Mutual. And the concern that we have there, if we create that bright line rule, there's now a trap. And the trap is that an insured can report any minute amount of damage and limit it to that, to have the insurance company limit its investigation to this small aspect of damage. And by issuing a coverage decision on that, the insurance company has then bound itself to only those policy provisions. And then later, the insured can come and say, well, all of this damage is now included, but you're limited to those only exclusions and provisions you cited before. And that is just an inequitable result. We cannot limit the policy like that. By the same token, an insured is not limited to what he or she claimed the cause of damage was at the beginning. That's the court essentially starts anew. We bring in facts and evidence to show what is damaged. We bring in facts and evidence to show whether or not that's covered by the policy and whether or not there was a forfeiture. We have to stay by the same rules that have been in place for decades. And knowing giving up of a right, that is a waiver. That wasn't shown in this case, and that was submitted to the jury exactly as it should have been. And this court has said many times before that if we have a dispute on the facts, the trial court cannot take that away on directed verdict or as a matter of law. It has to go to the jury. And that's exactly what was done in this case. And I'd also like to say that the exact same thing is true of the second issue on appeal. Essentially, in that issue, plaintiff is asking for an absolute rule that in any leakage situation, a homeowner is entitled to coverage for the first 13 days of damage, regardless of anything else that's going on. The flaw in that position is the conditions defense. It doesn't matter what the issue is, if there's a failure to comply with conditions that causes prejudice and that prejudice cannot be overcome, there is no coverage. And that's what opposing counsel is missing on this situation. Counsel brought up I believe it's pronounced Ifergain versus Citizens case. That was on appeal twice. And actually the first time it was on appeal is very, very similar to what we have here. The trial court found coverage as a matter of law in favor of the insureds. And the appellate court reversed because there was a conditions defense pending. And the court's ruling was while the conditions defense is pending, there cannot be coverage as a matter of law. That's exactly what we're looking at here. If there was damage during the first 13 days, but there was a failure to comply with conditions, that is excluded. The other cases that are very, very similar to that is the Perez case. A directed verdict was reversed because there were questions of fact on the late notice and the prejudice issue. Again, that's exactly what we're facing here today. And there is no way that we can find or that we can instruct the trial court to find coverage as a matter of law when those defenses are pending. And those defenses need to be considered by the jury. Ultimately, the jury weighed all of the evidence, found that there was prejudice that wasn't overcome, and that's what resulted in the verdict for Liberty Mutual. There was no waiver and there was no coverage. And all of that was decided by the jury as it should have been. We cannot take that away now and say that there was no dispute of evidence when it certainly was and was decided in Liberty Mutual's favor. So unless the court has any other questions, I'll be happy to rest on our brief.
All right. Thank you, sir.
Thank you.
The reason in this case why the jury verdict needs to come back is because it's an issue of law. So it went to the jury because the court didn't rule on it, but it never should have gone to the jury. So this isn't a case where the jury made factual determinations that should be given some deference. This is a case where all the cases in the insurance context, every single one has held as a matter of law that if they deny it based on the policy exclusion, they waive conditions. And as a matter of law, the court did not go that way. That's the only reason why it was submitted to a jury. And I think their argument shows a good example of why that is. They say that it's supported if such an action would be futile. Well, you look at this case, taking their own evidence, if you take it and agree with them, they inspected the property. They say maybe they asked her to send them some documents. They denied it within 2 days later. They never even waited to see, based on their own evidence, if any information would be presented. Instead, all they did was deny it, saying it's excluded by this 14-day exclusion, which they now concede they're wrong. They concede that their denial was wrong, and there's coverage for the first 13 days, as we had argued. The only case they mentioned in this court was the Aetna case, which is a liability case, which has nothing to do with this context in this case. And their reservation of rights letter only speaks to an exclusion. Completely different. You can't create coverage that's not otherwise available, meaning if it's excluded under the policy, you can't say the insurance company did something, so now my claim is covered. They agree there's coverage available. The complete difference is there's a complete difference between an exclusion and a policy conditions. Policy conditions, the law is very clear, is not favored, and those absolutely can be waived. So the sole issue in this case is they denied it based on an exclusion, never mentioned conditions whatsoever, and waived them as a matter of law by doing so.
But counsel, my colleague quoted Spiro Agnew, if I could quote late President Reagan, trust but verify. I understand your argument about maybe giving some more time to get more information from your client, but the notice provision isn't the purpose, one of the purposes, to allow the insurer to independently collect its own information.
With all respect, I think the Sparrow quote trumps in this case, which I believe was something along the lines of, look at what I do, not what I say. And that's what you do here. Look at what Liberty Mutual did. It denied the claim, saying it's excluded within 2 days of its inspection, never raised the policy condition once. That's what they did. So you look at what Liberty Mutual did in this case. They said they denied her claim. They said their claim's excluded. As we now know, their exclusion was wrong. And they can't go back, as they did in this case, by trying to come up with other reasons, conditions, when they never saw it, because conditions are a forfeiture. So I think in this case, you look at what Liberty Mutual did. They denied the claim. Their denial was wrong. And based on that, their only other thing they have left is policy conditions, which they waived as a matter of law through their erroneous denial. So for that reason, we think it has to be reversed on that basis for further proceedings, and we would just have a short trial on damages to establish the damages that occurred within those first 13 days.
Thank you, sir.
Thank you for your time.
Thank you both.
All right. We will be in recess.